Hey, bro. I'm here, Santa Claus. I like the shirt.
You see Greg and I fighting over this all week. It's too cold in here. You're going to tell me it's not cold enough.
That's a staff. Yeah, so she's gonna that guy right there. So you want to I'm trying to help you.
We will be starting the commission meeting in approximately 1 minute. Call the South Dakota Public Utilities evidentiary hearing to order. A couple of housekeeping. First, obviously, if you haven't been told a million times at the beginning of a meeting, please silence your phones. We appreciate that very much. Something you've never heard before probably is that the chair has dry eye and my eyes water constantly, and so I will be drying them constantly. That's no reflection on my feeling towards any of the testimony. We will begin the evidentiary hearing in docket HP 22-001 regarding the application by SCS Carbon Transport LLC for a permit to construct a carbon dioxide transmission pipeline. It is approximately 9 a.m. It is Monday, September 11th, 2023. The location of the hearing is the KCTIP South Dakota Bodega Center, 2010 Verendry Drive, Fort Pierce, South Dakota. I am Commission's Vice Chairman Gary Hansen. I will chair this hearing because Chairman's Chair Chrissy Fegan appropriately self-recused herself. Commissioner Josh Hader, who was appointed by Governor Nome to act as commissioner in place of Commissioner Fegan, and Commissioner Chris Nelson are both present. This hearing was noticed pursuant to the Commission's order for and notice of evidentiary hearing issued on August 14, 2023. The hearing is scheduled to run today through Saturday, September 16th, Monday, September 18th, through Thursday, September 21st, and Monday, September 25th, through Thursday, September 28th. The issue at this hearing, as set forth in South Dakota Law 49, 41B, 22, is whether the applicant can prove beyond a preponderance of evidence that the proposed project will comply with all applicable laws and rules. The project will not pose a threat of serious injury to the environment, nor to the social and economic condition of inhabitants or expected inhabitants in the siting area. The project will not substantially impair the health, safety, or welfare of the inhabitants, and the project will not unduly interfere with the orderly development of the region, with due consideration having been given to the views of governing bodies of affected local units of government. Based upon these factors, the Commission will decide whether the permit should be granted, denied, or granted upon such terms, conditions, or modifications of the construction, operation, or maintenance as the Commission finds appropriate. Petitioner Summit has the burden of proof to demonstrate its right to relief as requested. All parties have the right to be present and to be represented by an attorney. All persons testifying will be sworn in and subject to cross-examination by the parties. The Commission's final decision may be appealed by the parties to the State Circuit Court and to the Supreme Court. Adam DeHuick, our Commission counsel, will be the hearing examiner, and he will conduct the hearing subject to the Commission's oversight. He will conduct the trial and provide rulings on procedural and evidentiary matters. The Commission may overrule his rulings throughout the hearing. Our court reporter, you probably noticed that I slowed down after halfway through my presentation, is is Sherry Whitler. She's here to transcribe the meeting. So I'd like to remind everyone to speak at a normal pace so she can accurately transcribe what is said. Most of us speak a little bit faster when we read, as I have. So remember, you need to speak at a normal pace if you are reading, or in case there's any auctioneers in the audience. Adam will now take notice of the parties who are present, and then we have a number of motions that we will take care of. Adam?
Good morning. Thank you, Chairman Hansen. Hello, ladies and gentlemen. My name is Adam DeHuick, and as Commissioner Hansen pointed out, I'll be conducting the hearing, essentially sitting as the hearing examiner, in other words, the judge of this hearing. For the public's note, a pre-hearing conference was held last week on Friday with the parties who were seated at the table. It was a productive pre-hearing meeting, and after we take appearance of the parties right here and now, I will give a short summary of some of the items that were discussed, mostly for the commissioners' benefit, because I don't believe any of the commissioners attended the virtual online meeting, nor would I expect them to. So with that, we'll go around and take appearances of the parties, and we will begin with the party we will refer to as applicant or summit. Go ahead.
Good morning, Mr. DeHuick. Brett Hennick, at the podium on the wall for the applicant.
Thank you. Moving next to the group of folks that we are terming the ethanol interveners. Ethanol?
Good morning, Mr. DeHuick. Bill Van Camp here representing the ethanol plants that have intervened in this matter.
Thank you, Mr. Van Camp. And our next intervener is, please go ahead.
Thank you, Mr. DeHuick. Ellie Bailey, appearing this morning on behalf of Interveners, South Dakota Association of Rural Water Systems. and South Dakota Rural Electric Association.
Thank you very much, Ms. Bailey. And directly to your side is an empty chair labeled as SDTA. Ladies and gentlemen, that stands for South Dakota Telecommunications Association. They are an active participant in this case, but at the preliminary hearing we had last week, they mentioned they won't be really sitting at the table, and they'll come in on the day that they need to come in for their lawyer work. So with that, Kara Semler is representing SDTA. Turning next, just to keep things in order of the room, I'll go to the next table where we have the group we refer to as commission staff. Staff, if you want to identify not only who you are, but who you are.
Thank you. This is Kristen Edwards representing Commission staff. I am joined by attorneys Amanda Reese and Logan Schaefbauer. I'm also joined by analysts Darren Carney and John Thurber.
Thank you. And at the table to staff side is another grouping of interveners. Again, chairs are empty, lawyers are not present in the hearing room. We have the county being represented by Alex Hagan, I see the sign there, and there's several other counties too who are also not present. I suspect the name placards reflect probably Spink County, McPherson County, Brown County, and then the next grouping of interveners would be Webb Water Development Association, who is also an active participant, but again, at the preliminary meeting, identified they would not be present. Next to those folks is the biggest group of interveners that we refer to as landowners or interveners generally, and I will let those two attorneys identify themselves for the record.
Yes, thank you, Mr. Buick and commissioners and council. Brian Jordy and Ryan Schwach on behalf of landowner interveners.
Thank you very much, Mr. Jordy. Ladies and gentlemen, at this table, this is obviously the commission table. Down at the end, we have a commission advisor by the name of Greg Grislow, myself. Again, you know me as Adam Hewitt, the hearing examiner at this moment, also commission advisor. And then commissioners have been introduced. With that, I said I'd give just a brief summary of the preliminary hearing we had back on Friday. I shouldn't use the word hearing. It was just a meeting to discuss procedural matters and get the parties up to speed on how we want this case to flow and how we want to be efficient and effective and maximize our time in this room as efficiently as possible. And the meeting was very good, commissioners. All these folks were in attendance. We discussed evidentiary objections that the parties will make to the presentation of each other's testimony and exhibits. So you will hear lawyers object along the way, and I will either overrule or sustain, and the commissioners who have ultimate authority over me can overrule my decisions along the way. So you'll see a lot of that as we proceed. We discussed a list of stipulated exhibits that parties would agree to without further quarreling over the legality of their admittance. We discussed the tentative witness schedule as to the order witnesses will be called upon by their representation and what order the parties will go in as we proceed. And we discussed several other miscellaneous items such as the process for cross-examination, the order in which each party gets to ask questions of the witness on the stand and subject them to what we call cross-examination, in other words, interrogation. With that, unless there's any questions from the commissioners about the preliminary hearing, I am going to give the gavel back to Commissioner Hanson, who will conduct these motions just as we would in a normal commission meeting setting. Commissioner Hanson, are you ready?
Thank you, Mr. DeHuey. Around Wednesday to Thursday, the commission received approximately 300 different documents to file. So we've been hurrying, I should say staff has been doing an incredible job of putting a lot of information together for us and a lot of reading over the weekend. Among those documents was a withdrawal notice from Summit of its motion for request to preempt the county ordinances, which we have always accepted when when someone makes a motion and then wishes to withdraw it, regardless of who they are, as long as it's their motion. So that's accepted, of course. We also received several motions from staff. We received a motion to amend a filing fee, motion to deny the application, and a motion objecting to the testimony. Traditionally, we would receive these earlier, and we would deal with them at an earlier time, and we would deal with them at a regular commission meeting. So today we will deal with those as we would in a regular commission meeting. We will take up the motion to deny the application first, and that was submitted by Ms. Edwards. And so I will turn to Ms. Edwards for comments on her motion.
Good morning. Staff filed the motion to deny the permit after it became abundantly and undeniably clear that Summit cannot obtain a permit at this time. In their response, Summit argues that SBCL 4941B22 subpart 1 is forward-looking, and the Supreme Court has recognized it as such. Having been a part of that case before the Supreme Court, I don't disagree with the interpretation of that case. However, SBCL 4941B28 is not forward-looking. And it was also not relevant in the case that was considered by the Supreme Court, because SBCL 4941B28 does not apply to wind farms, and that Crown Ridge case dealt with a wind farm. 4941B28 applies exclusively to transmission lines and specifically to the route. Therefore, the Crown Ridge case cited by applicants is distinguishable and irrelevant. SDCL 4941B28 prohibits the Commission from issuing a permit for a route that violates the county ordinance. There is not discretion within that requirement. Summit's route violates county ordinances, and without preemption, which Summit is no longer requesting, there is simply not a path forward. I know that in many respects it feels like we have been waiting for this hearing for a year and a half, and that we are at the 1 yard line with staff asking us to call the game. And I know that's an odd feeling. But the fact of the matter is, we're not at the 1 yard line. Maybe we're at the 50. An evidentiary hearing is a massive undertaking, and it makes little sense to go through the motions of a 3-week evidentiary hearing and all that would follow without a compliant route that can be permitted. We've all put an incredible amount of work in over the last year and a half, and a week ago, I would not have imagined that I'd be before you making this motion today. But the game completely changed last week. At this time, and under the current timeline we're up against, events of the last week have presented a challenge which Summit cannot overcome. Even before Summit withdrew its request for preemption, the findings in the Navigator case decision last Wednesday presented Summit with an impossible challenge based upon that precedent. Quoting Mr. Powell's testimony from his rebuttal testimony found in Exhibit A34, which was pre-filed, at line 150, quote, when SCS submitted the initial filing on February 7, 2022, SCS committed to design, construct, operate, and maintain the pipeline and well sites in compliance with South Dakota statutory requirements in effect at that time. SCS can no longer honor that commitment, end quote. It is clear from a review of the facts and circumstances that gave rise to this motion that while the route fails in 4 counties, One county ordinance is the greatest Achilles heel for this application, and that is Brown County. The Brown County ordinance requires the pipeline to be set back at least 1,500 feet from the property line of cautionary uses, including houses, schools, daycares, and churches. While the landowner may sign a waiver of the 1,500-foot setback, the waiver would need to be approved by the county zoning board, and those waivers would need to be approved in conjunction with an application for a conditional use permit. The constraints map applicant filed with the rebuttal testimony demonstrates that the 1,500-foot setback is fatal to Navigator's proposed route. The need to obtain waivers and have those waivers approved along with the CUP from the county is just too many conditions prerequisite to put the route in compliance with the Brown County ordinance within the realm of reasonable speculation. In addition, on Friday, staff sent a data request to Mr. Jordy seeking information as to whether any of his county clients in Brown County would even be willing to sign such waivers, and the response was that at least 18 would not. As stated in our motion, there were material statements contained within the application that can no longer be true. It was a misstatement to say that the application will comply with all ordinances. Therefore, the application should be denied pursuant to 4941B13 sub 1. In addition, the application should be denied pursuant to 4941B13 sub 2 because the application is no longer in the form and content required by Chapter 4941B and ARSC 2010-22, specifically as to the failure to comply with the information required in 2010-22 sub 19 as laid out in our motion. Nothing in this motion should be read to be staff taking a position on the remainder of applicant's burden of proof under 4941B22, specifically subparts 2 through 4, and nothing in this motion should be interpreted to imply that staff would take a negative position on the permit if it complies with all county ordinances. That decision has not been made by staff, and that is not on the table today. If this motion is granted, applicant would have every right to reapply, and we would fully expect them to do so. That's also where their arguments about the time and money put into this docket failed. All of the work done to date, including Summit's responses to staff's numerous data requests, can be filed with the new application, picking up where they left off, but with 12 months to make progress in the areas with the counties. In closing, I want to read to you the last sentence of SDCCL 4941B28. It provides, without such a finding by the Commission, no route shall be designated which violates local land use or building rules or regulations or ordinances. Summit is no longer asking you to make such a finding. Their route violates county ordinances. No route shall be designated, to quote the statute. Thank you.
Thank you, Ms. Edwards. Mr. Kanke?
Thank you, Commissioner. I think it's appropriate since the landowner joined in the motion that you hear from them first.
I'll do that. I was going to go around and see if anybody else wanted to comment, and then give you an opportunity again to reply. But if you wish to proceed that way, that's fine. As a joiner, Mr. Doherty?
Yes, thank you. And I have a series of exhibits I'd like to offer in support of our joinder to this motion. The first would be A, and that's A for applicant 34, and its attachments 34A, B, and C. That is Mr. Powell's pre-filed testimony, one of them. I can keep going down the whole list, okay?
I haven't heard any objection to.
Oh, okay. All right.
There will be other.
Thank you. Then Mr. Skubinik's pre-filed testimony, A46, and his attachments, A46J, K, L, and M.
Do you have no objection? They are entered.
And I should be clear, these are offered only for the purposes of this motion at this time. I'd like to offer this supplemental application, October 13th, 2022, particularly section 5.5.4.
No objection. They are entered.
Landowner Exhibit 187, which is Summit's council email relative to these motions out to all other party council of September 7th, 2023.
No objection. They are entered.
LO 188 are true and accurate copies of 4 federal lawsuits Summit has filed against Spink, McPherson, Edmonds, and Brown counties suing them.
No objection. They are entered.
LO 189 is a partial list of lawsuits Summit has filed against a series of South Dakota landowners regarding survey access.
Is there an objection? No objection. They are entered.
LO 190 is a partial listing of condemnation lawsuits Summit has filed against landowners that it seeks easements from for this particular route.
No objection. They are entered.
And I don't know if they've been uploaded yet, but I'll represent that LO 191 are signed statements of 11 of my clients in Brown County who will not sign waivers, and LO 192 that also might be in the process of being uploaded is a collection of 7 additional signed statements by Brown County landowners who will not sign waivers regarding the 100 or 1,500 foot setbacks. And so I would offer those.
Mr. Kennedy?
They're not uploaded, Commissioner. I would object to those, and I can see those.
Okay, well, I would, I guess, re-offer them while they're being uploaded if we circle back around. But in any event, I can represent that I have in my hands right here 18 signed statements of Brown County landowners stating they will not sign a waiver for Summit in Brown County.
Subject to them being downloaded or copies being distributed to everyone, they will not be included.
Understood, and I think that's in progress. And with that concludes the evidence I have, and then I do have argument. So, landowners concur with staff. Everything you just heard from staff is well reasoned under the law. There may be this idea that, well, gosh, we're already here. Why don't we just go forward? But where the kind of the game analogy, you can't change the rules in the middle of the game. We're on the 1 yard line. Where that all falls apart is Summit is asking the commission here to do something that is an impossibility. The application before you, they have already stated in their own words, we cannot comply with the ordinances, and therefore the route we are seeking approval of cannot be constructed, cannot be located. And so there is no reason for all of us to devote the next 3 weeks or more of our lives to an application that by their own admission is an impossibility of ever coming to fruition. And that's not something we cooked up over the weekend. That's their statements that are now in evidence before you. The argument really is as simple as that. It's not kind of, well, we've all done so much work, let's just go ahead and see what happens. They have told us their route they are asking for approval cannot be built. So we do not need to be here. In regards to the one sole Supreme Court case cited in Summit's brief, it is precisely in opposite to what we have going on here. In that case, Crown Ridge, which this body knows well, already had a conditional use permit in hand. They had already gone to Grant County. They had received a conditional use permit on the noise, the sound ordinance, and they already had it. They already took the steps to comply, which is what the directive was just a short week or two ago to Navigator. You haven't exhausted your remedies. You haven't even attempted to get a waiver. You haven't even attempted to get a conditional use permit. And so in the case they cite to support their position, that applicant already had a conditional use permit. And then they came and presented evidence after the ordinance was strengthened a bit to make compliance maybe slightly more difficult. They presented evidence before you. We've got the CUP, conditional use permit. It's still valid. And not only that, we can comply with the more stringent ordinance that was amended during the pendency of the application process. That is nothing like what we have here. They have told you they can't comply. They haven't tried to comply. And the best evidence we have is an email from the council on someone's behalf saying, well, you know what, I'm filling in the blanks. We saw what happened with Navigator. We're pulling our request to preempt and just do away with all concepts of local control, intelligently so. And we're going to go back and try to work with the counties. Well, you already told us it's impossible. So this isn't a forward-looking, given the benefit of the doubt, let's go through it. You can't condition this into approval because they've already told you. And so we have the juxtaposition of, was the application true? Was Mr. Powell and Mr. Skumanek's statements, were those true? We must accept them as true. They didn't ask to modify a single statement, and now they're in evidence, right? So they are standing by and living by the statement, our route cannot comply. That's it. It is over. I could go on, and it seems like I should, because it is a big decision, but it's actually a simple decision based on the facts and the law before you. The sections of South Dakota codified law that apply to wind have nothing to do with what we're doing here. The bar is much higher, and 49-41B-28 precludes the commission from, quote, designating a route which violates local land use zoning, comma, or building rules, comma, or regulations, comma, or ordinances, end quote. They're asking you to do an impossibility. It cannot be done. Now, to Ms. Edwards' point, this isn't, a statement that the PUC is against the concept of CO2 pipelines. That's not what this is about. Or they're against Summit. That's not what this is about. I have full confidence Mr. Koenneke and his client will do what they can to reroute, to do workarounds such that they can, and come back with an application that could potentially be approved. But taking away all the we don't want it, they want it, the animosity, everything that has gone on to get us here today, strip it away. This is a purely legal question, and we win on their evidence alone. And so with that, landowners join and respectfully request that this commission deny the application and that there be a motion to approve staff's motion requesting said denial. Thank you.
Mr. Koenneke.
Thank you, Commissioner. Appreciate the passion with which my opponents have stated their cases here this morning. I want to back up a little bit. I suspect that this project is ultimately going to be built. I've permitted a lot of projects, and this one has all of the indicia of the other ones, which are technical, superiority, and parties on both ends who wish to buy and sell or deal with the commodity that's at hand. I think that's the case here. I'm not arrogant enough to think that this application is going to be somehow rubber stamped by you as commissioners, but this project is ultimately going to be built. It's too important to too many people, both within this state and without. Carbon capture is the future of agriculture, and certainly the future of the ethanol industry. And so with that in mind, I want to point out that despite the opposition that this project faces, it has broad support. The project traverses 18 counties. 4 of those counties have taken action. that's at issue here this morning. We've got easements from 72, 73% of the landowners which the route crosses. And so I do want to point out the broad support that this project enjoys. I don't want to deny that there's opposition, but there is broad support. I also want to note that we didn't seek to change the law to build this project. This project was designed in compliance with state law as it existed at the time. The one law we sought to change was to ensure that the tax code of the state properly included this project along with other centrally assessed projects so that there wasn't confusion in the counties or within the revenue department or within my client or anybody else. That's the one law we sought to change, was to say we want to be taxed like everybody else, nothing different. But the rest of it was designed to comply with state law, which is the stated public policy of the state in these counties. And opponents to the project had to change the law in order to bring us to this point this morning. Opponents had to do that. I want to point out that Mr. Jordy brought the first lawsuits involving the project. His clients are the plaintiffs, and they served us. And I think that's an important distinction that ought to be brought up here this morning as well. With respect to the counties, it's doubly unfortunate that their action has come this late in the process. It's very difficult to change maps and routes and undo and redo commitments to landowners and to this commission and to the people of the state who are on the outside watching when we're 14, 18 months in, and then we have to react to statements made by the counties. With that said, we have hundreds of positive interactions with the counties which are on record. And that's shown in the 14 counties that have considered this project and decided that well enough is well enough, that we're going to be okay here. There is a broad base of support out there. It's not about 4 counties, it's about 18. 14 of which have said, I think we're all right here. And I want to point that out as well. That said, the 4 ordinances that are at issue are significant, and we heard the commission loud and clear last week. I was in the room along with Mr. Honeywell, and a number of the people seated behind me were listening to the discussion which was held. And that doesn't give us a lot of time to react and respond to that either. I think those are important considerations that ought to be pointed out. But with respect to those 4 ordinances, the locations, the issues, the personalities are different, and we know there's work to do there. And I want to express the commitment of the company from the highest levels of ownership to executive level to management and the experts arrayed behind me. We're prepared to go out and do that work. We know what it looks like, and we know that it takes people on both sides to communicate and discuss needs and wants and listen more so than talk, reason with each other, share experiences, and have conversations which lead to the ultimate conclusion that I started this speech with, which is that carbon capture is the future of agriculture. I think that I'm going to stand on the recent case law and the language of 22.1, whether it's a wind farm or whether it's a transmission project, a project that will comply with all statutes and ordinances is always forward-looking. Nothing's been built yet. We can't turn a spade until you give us the order that we can do so. So that's always forward-looking, and it has to be that way, and the cases, I think, demonstrate that. That's how we've always understood it on my side of the table here. It has to be forward-looking because nothing's been done yet. And so we sit here ready to prove the technical aspects of this application. We've spent hours and nights and weekends, and one notable exception for a football game on Saturday. We've put in the time and effort, and we respect that other people in the room have done the same thing. So I want you to know we are here ready to prove the technical aspects of this application. It's very important that we be able to do that and demonstrate the high level of quality and excellence that we're going to apply to this project, so that people can hear and test our evidence and test our arguments and come to understand better what we're trying to accomplish here. So with that, Commissioners, I do wish to go forward with these hearings this morning. We've got plenty of people in the room. We're teed up. We've got tables and microphones and wires and books and computers and all the things that are necessary. And our wish is to proceed to prove those technical aspects. The law allows us to come back and prove the other aspects that you might deny upon. And that's our wish and will and intent is to go forward. Thank you.
Ms. Edwards, it was your motion. Do you have anything to refute or rebut at this time?
Commissioner Hanson,
Yes.
may I address the motion and as an intervener?
Mr. Van Camp, you may.
Thank you, Mr. Chairman, members of the commission, Bill Van Camp. I'm here representing Ring Neck Energy, Glacial Lakes Energy, Dakota Ethanol, and Redfield Energy. And while they haven't been as vocal in this process as some of the opponents might have been, those companies employ right now over 200 South Dakotans. They buy over 200 million bushels of corn annually in this state. And I'm going to agree with exactly what Mr. Kennedy said. Carbon capture is the future of the ethanol industry in South Dakota. And that's why those companies are here looking for this matter to go forward, looking for this project in some manner to go forward. Why Walt Wetland is sitting next to me, the chair of the South Dakota Ethanol Producers and the president of Ring Neck. I think the case law is, as has been briefed, but I think this commission needs to consider that SDCL 4941B 28 is not being asked by the applicant to be ignored. If you look at the last sentence, the language of that code that was read by Ms. Edwards, it states that no route shall be designated which violates local land use. Summit's not asking for that. They certainly aren't. Subsection 28 can be read with subsection 21 and the standard identified by the Supreme Court in the Crown Ridge case to put a requirement on any application or permit that is issued, I'm sorry, not application, but a permit, that it must be in compliance. Now, they might never get there. That's entirely possible, as much as I hate to admit that fact. But, as the court said in Crown Ridge, and I'm quoting here, it's not to say that the PUC should not consider where the applicant has procured the necessary authorizations from local authorities or its current compliance with various regulatory requirements of such government bodies as a means to predict future compliance with applicable laws and rules. This is certainly an appropriate area of inquiry. So the commission can consider the likelihood of whether or not Summit gets there. And it can consider in any issuance that it makes as a condition of the ability to turn that first spade, as Mr. Kennedy said, that they do in fact get there with those counties in whatever manner they're able to. But I don't think we're at a point where this hearing has to come to an end today. I think the applicant can put on their case, the commission can consider if it will be able to reach a point, and as a condition of that presentation, if this commission is willing to say that they can proceed provided that they meet those requirements of those specific locales and obtain those permits, waivers, or address it through other means at the county level. They've made the offer. I think we should go forward, and I hope that the commission will agree. Thank you.
Thank you. Is there anyone else wishing to that is a party. Ally, no? Thank you. Ms. Edwards?
Nothing we heard here this morning directly rebutted the fact that Summit cannot comply with the last sentence of 4941B28, particularly in Brown County. They didn't explain to us how they plan to do that. Also, this motion isn't about the future of agriculture or attack on the ethanol plants or taking a position against them. This motion is simply about the law. And again, Summit would have every right to come back with a new application with fresh facts, having worked harder and taken some time to step back and work with the counties and reapply. We would fully expect them to do so, and we would look forward to working through their application at that time. Thank you.
Thank you. We will turn to commissioner questions. I have a few questions, and I suspect my fellow commissioners will have some as well. Questions of Summit: how long do you anticipate that it would take to comply with county ordinances? If you are asking us to go through this process.
Commissioner, I would think 90 days would be a number to throw out there to start. It's important to note that communication with counties and with the landowners would involve a number of parties and communications and individuals, and some of those might not be willing to have conversations. It's very difficult to say, but 90 days is a number that pops into my mind. I would throw that out for your consideration.
Having been in local government for nearly 15 years prior to this, I know that there's a lot of work through the process of legal notices, and you have to wait in between those. You have to have first and second readings, and you would have to make applications and get waivers and on and on. Considering that, you still think the 90 days?
Mr. Mayor, I'm arrogant, but not arrogant enough to tell you how the local government process works.
All right. You state that 72% of the landowners have signed with, I'm not sure if those are easements, waivers.
They're easements, Commissioner.
Okay, and certain, are those, does that include surveys too? I assume they're allowing people to, well, Navigator only had 30%, and Navigator was not suing anyone. So I'm wondering if we take into consideration the potential concern for lawsuits. So how many lawsuits did Summit pursue, or how many have they filed over this process for easement purposes?
I'd like to change your question to how many were participating in, because as I said, a number of them were instituted by landowners themselves, but it's in triple digits, Commissioner. There's a number of parcels at issue and a number of interpretations of law that are at issue. I would want to state for the record, we didn't sue counties for damages. We sued them in order to have a dispute over what the law says about land use and what the boundaries are around counties with respect to things like the Natural Gas Act. And so in order to have those disputes determined, you have to go to court and you've got to serve people and allow them to come and have their day in court and explain to the judge why they see the law a certain way and why we see it differently.
Understood. However, I'm concerned with how many easements you pursued. Do you have a number?
150 or 160 to my best knowledge. 72%, Commissioner, are voluntary easements.
I understand. Would you agree that voluntary is a relative term, and if someone voluntarily signs, they could be intimidated through the process of seeing their neighbor sued and realizing that they do not have the opportunity to win that lawsuit? so they reluctantly sign. Would you agree that that occurs?
Commissioner, I wouldn't speculate what people's motivations are.
Another question, compliance with local ordinances can come after a permit hearing, you argue. Concern that I have is a permit cannot legally be issued if evidence shows that the applicant cannot comply with all the rules, regulations, laws, including local government ordinances. So how would we continue a hearing knowing that legally we cannot provide that permit because you cannot comply with sub 1 and arguably sub 4 of the statute?
Based my argument, Commissioner, on the language which allows us to proceed to prove parts of the application, the 4 factors in section 22. And there's certainly, our outreach to the counties has been ongoing since before this docket was filed. And that outreach continues and will continue. And our thinking is that if we can prove some of the 4 factors, that perhaps by the end of this proceeding or certainly prior to construction, we'd be in a place where we could meet the 4 factors squarely.
Well, in reading the law, you emphasize the word will, that the applicant must prove that it will comply. Doesn't will comply more than infer? Doesn't it mean that they can that they can comply with the statute?
Commissioner, I think it means that they will comply at the time the project is constructed and during the time it's operated.
You speak of all of the work that has been done up to this juncture. However, that's obviously a necessity and responsibility of Summit, correct?
It certainly is, yes.
And that is not all lost if certainly all the work that staff has done, and you talked about wires and setting up and all of that, this tremendous amount of work, that will be lost. The amount of work that staff did in trying to organize everyone, and that will be lost, and staff would have to go through that process all again. However, the applicant merely has to proceed with completing their application. So you still have all of that equity, you still have all of that work that's been done. So it's not like saying they're on one yard line when we all know all of the tremendous amount of work that's going to proceed here, don't we?
I certainly do know the work that went in on our side of this hearing. I respect the work that's gone in on the other side of the hearing. I don't want to minimize any of that. You're certainly correct when you say that there's a lot here from which to build. I think that's what your comments were directing at, and if not, I'll obviously take correction from you. But I do think that a substantial amount of work has gone into preparing for this hearing that could be utilized going forward, and we'd sure like the chance to do that.
Those are all the questions that I have at this time. I have a few more, however, I'm going to move to Commissioner Nelson and see if he has any questions at this time.
Thank you. I do. Ms. Edwards, as so often happens, there are things that are rolling around in my mind, and obviously after Wednesday of last week, there were a lot of things rolling around in my mind as related then to Summit. And as so often happens, staff all of a sudden shows up with a filing that seems to reflect a lot of what's rolling around in my mind. And so I appreciate your filing, but I've got some questions. And I guess the first one from your motion, the first paragraph, you asked for a motion to deny the application. My first question is, why did you choose deny as opposed to return?
I contemplated that, and I read return to be more of when we first get an application and we review it to make sure that it can be posted on our website and filed in public input meetings scheduled. That to be more of the immediate review, and the deny would come later. But it was just a preference. I think they ultimately mean the same thing.
Well, I'm not sure they mean the same thing. It might be the same outcome for today, but I'm not sure they mean the same thing. And I'm not, I understand your answer. I'm not sure the statute confines it to the immediacy of filing that you were talking about, but let me expand that. Why did you choose deny as opposed to asking us to simply indefinitely postpone this hearing to allow Summit an opportunity to resolve these issues?
That's certainly an option that, you would have, and we contemplated that and decided that just for conservation of resources and staff time, taking a step back and having them start over was more prudent. We also understand there to be potentially another application coming to add another leg onto this project, and I think that was alluded to in their response. So it seemed like a better use of resources to hope that the reapplication and the additional leg of the project could just be rolled together into one new application, and we could handle it all at once.
Forgive me, Commissioner. May I interrupt?
Certainly.
Answer your question. Actually, statutorily, we do not have the authority to defer application because the statute requires us to accomplish it within a 12-month period. 3 years ago, Mr. Kennedy and I worked on the statute, went through a great deal of Mr. Van Camp was a part of that as well, along with several other attorneys. And I was working to try to change statutes so that the applicant and any of the other parties could make a motion to extend the duration. However, it was a very complicated and lengthy statute. Agreed to only allow the applicant to make a motion to extend. So that is how the statute reads at this.
The fact that the applicant has waived, we as a commission established November 15th deadline. I think it is within our purview to extend that. My opinion. Right. At the bottom of the first page, proceeding with waste resources that have already been, and hence that was part of the reason I asked the denial as opposed to a deferral. Yeah. But I do think y'all need time to get this. Well, let's make it was impossible based on their testimony. And hence, I had to find that they could not comply with that prospectively because it was impossible for them. And so my question is, why are you not in the same boat? I mean, your testimony of your witnesses versus where the project is at and where the counties are at this point, it appears to me that it is an impossibility. Explain me why it's not.
I appreciate the question, Commissioner, and I'll go back to my thoughts that I shared with you at the outset about the importance of the project and the numbers of people and entities who are in support here. And it's well past 50% plus one. I think by any measure that we could apply, it's well past that. And there are matters of importance to enough people who are participants in agriculture that lead me to the conclusion that this project is somehow going to have to succeed. And I'd love to be able to tell you what the roadmap looks like. All I can do is tell you I can see that point from my experience, which is fairly substantial, as you know. I can see that there's a way to get to yes here, but what the roadmap looks like for us to all get there, I can't say with specificity. What I can say is I know how to do it, and that's through conversation and adjusting and talking. And I would love to tell you how long that's going to take, and I can't do that either, because I can't for the people who are right here opponents or at the counties. I need to speak to them and with them, not for them. And so, again, I wish I could give you a more concrete answer, Commissioner, but that's the best I can do here this morning.
And that process will simply take time, correct?
It has to, because people on the other side have to react and respond and share their thoughts.
So maybe the last question I'll ask you is, the last sentence of section 28. I don't see how we get around that. And there's a lot of me that does agree that it feels like we are on the 1 yard line. I mean, we've all waited for this day for a year and a half. And I am so mentally ready to go forward with this hearing, it's unbelievable. But we can go through this in 3 weeks, and at the end of 3 weeks, the last sentence of 28 is still in this law book. How do I get around that at the end of 3 weeks?
Commissioner, can I have 5 minutes to consult with my clients?
Absolutely.
Thank you.
What? Hey. Huh?
see if I say one question. We will begin. I'm surprised to see there. Yeah. I think. I think that's
The hearing will reconvene in 1 minute. Boy, I wish I could quiet a room like that when I'm home.
Thank you very much, Commissioners. It's important for me to be able to consult with my clients. It's their project, not mine. And I tell them repeatedly I work for them, not the other way around. So I appreciate your indulgence very much. I'd like to continue to hear from Commissioners, and then I'll probably have a few things to say before you would proceed.
Well, with that, I would renew the last question that we left off with. We could go through 3 weeks here, and the last sentence of section 28 is still law at the end of 3 weeks. How do you propose that I get around that?
Commissioner, the best I can tell you is that it's for us to find that pathway forward and tell you what that looks like. And all projects have a date on which they get a permit. When they get a permit, they get that permit. And then they have to proceed to put that into action and into effect. And this wouldn't be any different in my mind. It would have to comply with the local ordinances and rules in order to become effective and to be put into effect and made real. And take the words from the paper and put them in the ground and do the job.
And so, if we were to move forward in making your case over the next 3 weeks, is it correct that necessarily a lot of the testimony of your witnesses that has been pre-filed would need to change?
I don't know what a lot is, Commissioner. It always changes over the course of the hearing. We pre-filed testimony months ago and things have happened since, and this docket is really not different from other ones in that regard. Things always are evolving through the course of the docket. Would some things have to change? Absolutely. And that's why we put the live witnesses on the stand to have those conversations about those things. I hope that's helpful.
It is. I think that's all the questions at this time. Thank you.
Commissioner Hayter, do you have any questions?
I've got some comments. I can hold those for a moment. If Mr. Edwards would like to ask a couple questions, but I do have some comments.
All right, then I turn to Ms. Edwards since there's been, is this, did I say Commissioner? All right, Ms. All right. Mr. DeHuey.
Thank you, Chairman Hanson. Commissioner Nelson brought to mind a couple of questions I'd like to ask, and thinking it over, I think I'll start with the applicant and Mr. Kennecke. If we were to move forward and not much had to change, and you received a permit from the commission to build the pipeline, but that permit said you have to obey all county laws. And we know you're not obeying it right now, but your permit says it's not good until you obey the county laws, and you can't build until you're in compliance. So again, a forward-looking permit like you were discussing earlier. And I know earlier you said you don't like to speculate, correct? But I think I'm going to ask you to. If you had a PUC permit that was just top-notch, top-of-the-line permit, that reduced the risks, increased your safety protocols and all this stuff, just the best permit that could be conditioned, would that not be a powerful bargaining chip when you go back to the counties and try to, I think you said you're having ongoing conversations about how to construct this through their county, is that correct? Can you give me your thoughts on what a well-conditioned permit from this commission might do?
I appreciate the question, Mr. DeHuick. I can't think of a permit that doesn't say as number one in the conditions that you have to follow all the rules. It's number one in the statute list, and I think it's always number one on the permit conditions, and so this wouldn't be different from that. It would seem to me to be comforting to everybody to have had a project vetted and have the testimony, the chance to ask witnesses questions under oath and consider the evidence. It would seem to me to be a benefit to everybody to create such a permit, but I can't say how it would be received by others for sure. That's a question for them.
No, thank you. Just one last question. The statute we've been talking about is 4941B28. That's the county preemption statute. Right before that is the statute 4941B27. When I read 4941B27, it appears to me that perhaps you could get a permit from this condition that said you have to obey all laws, and then it talks about maybe you have 4 years to work alongside the county and come up with an agreement. Do you see that in 4941B27? And maybe you could ask for preemption at the end of that 4-year period, come to the commission and say, it's been 4 years, the county's not changing their mind, we're now going to ask you to just thoughts on 27's applicability to the matter before us.
Thanks, Mr. DeHuick. I appreciate the question. I'm somewhat concerned about the last phrase where it says that such facility continues to meet. Continues is a word that I'm not sure makes that applicable. I hate to say that. I was liking your argument a lot until I got down to that line.
Thank you. And then staff, do you have anything you would like to say? Oh, okay.
Excuse me. Are you back?
Yes, with Mr. Kennedy, I wanted to start that question and see how staff thought about it.
All right. Further question, apparently Commissioner Nelson has additional questions, however, I have not turned to Commissioner Hayter yet, so Commissioner Hayter.
Patiently waiting.
Commissioner Hayter will await your question, Commissioner Nelson.
This would be for Ms. Edwards. You heard my discussion about my thoughts that it would be within our authority to rescind the order that we issued establishing November 15th as our deadline and indefinitely defer this proceeding. Do you believe that is within our legal authority?
It absolutely is. Yes.
If you are finished, Mr. Nelson. Ms. Edwards, well, I'll turn to Commissioner Hayter and give Ms. Edwards final comments.
Well, thank you. Of course, Gary and Chris, you asked some great questions. You asked all of my questions, so batting third can be tough sometimes. But let me just kind of tell you an outline where my headspace is at after the motion that I came out. It was a very long weekend, but I want to go through some of Mr. Powell's pre-filed testimony just to illustrate where I'm at prior to making a motion. So a question asked to Mr. Powell was, has SCS committed to design, construct, operate, and maintain a pipeline and valve stations in compliance with applicable zoning and county permit requirements? Mr. Powell's answer, and I quote, says, when SCS submitted the initial filing on February 7th, 2022, SCS committed to design, construct, operate, and maintain with South Dakota statutory requirements in effect at the time. SES can no longer have that commitment because 3 counties, McPherson, Brown, and Spink, have since enacted moratoriums that ban the proposed pipeline in 2 counties, Brown and Minnehaha, have recently enacted ordinances with setback requirements that would prohibit a pipeline from being constructed along the proposed route and make construction of a pipeline anywhere through those counties impossible or impractical. The next question to Mr. Powell, you stated earlier that the Brown County ordinance is unreasonably restrictive as applied to the proposed route. How? Just to outline Mr. Powell's response, the ordinance's 1,500-foot setback requirement are not only unreasonably restrictive as applied to the proposed route, they prohibit SES's proposed routes in Brown County. Furthermore, it says attached as Exhibit 3 is a map of Brown County that shows the areas in which Brown County ordinance prohibits the construction of the pipeline. The red line shows SES's proposed routes. As the map reflects, the proposed routes are not possible under the Brown County ordinance. And one more question I want to outline to Mr. Powell. You stated earlier that Minnehaha County ordinance is unreasonably restrictive as applied to the proposed route. How? In Mr. Powell's response, the setback requirements of Minnehaha County ordinance are not only unreasonably restrictive as applied to the proposed route, they prohibit the proposed route altogether. Attached as Exhibit 4 is a map of Minnehaha County that shows the areas in which Minnehaha County ordinance prohibits the construction of pipelines. The red line shows SES's proposed route. As the map reflects, the proposed route is not possible under the Minnehaha County ordinance. So also the applicant talked just a little bit about, they quote, must comply with all applicable laws and rules, that is forward thinking. It is my estimation after listening to the testimony today that Summit cannot demonstrate at this time or in the near future that they have the ability to route the pipeline as proposed. And so I would say I appreciate the arguments of the applicant today, but without the preemption, you've made it crystal clear in your pre-filed testimony that ordinances in various counties make this an impossible project at this time. So let me just make 2 more quick points on this. So my comments today should not be indicative of my support or lack of support for the project in general. And if the motion I'm about to make is not supported by my fellow commissioners, I'm more than happy and more than prepared to continue forward today and throughout the next 3 weeks with this process. With that said,
Commissioner, I hate to interrupt you. I didn't want to interrupt you at all. It would be my client's wish that we'd all go home today and that we'd be allowed to come back with a motion for a new scheduling order sometime in the near future when the facts and the needs of people are more clear. There's been a lot of moving parts over the last 5 or 6 days. And I would like to propose to you, I'm asking you to, if you find it necessary, I'll invoke the provisions of statute, despite me telling you I would never do that again, to delay the proceedings and give me an opportunity to come back to you with a new scheduling order. I apologize deeply to everybody who worked nights, weekends, and holidays to get to this point. But that would be my client's wish, is to come back to you with a new scheduling order for you to consider at that point, rather than proceed today to either a return or a denial. I can hear and I can see what the minds of the commissioners and where you're at, and that would be my request for you to consider that here this morning.
We are going to turn to Ms. Edwards. Thank you. Ms. Edwards, you have the final words before we turn to Commissioner motion and discussion.
Thank you, and I sympathize with the point that Mr. Kennedy is trying to make. There are certainly pros and cons with each path forward. We would just like confirmation that if continuance is the path forward that the commission chooses and that Summit's going to proffer, that the application that we were anticipating be filed within the next maybe 4 days, they would take a hard look at rolling that in and how we could maybe find a legal path to roll that in, so we would have one pending Summit application.
Would you run by your suggestion again? I was informing Commissioner Hayter that he couldn't make remarks prior to making a motion. He had to just make the motion without proceeding. So I missed a portion of what you said. Forgive me. And I don't think Commissioner Hayter needed the schooling, but that is I did to him.
Thank you very much.
I was just pointing out our concern that, as someone mentioned in their response, there was another line that they posted GVO that they would be filing a permit application for, and that would be a short line, and my guess would be about 50 miles. And if we could find a way to tie that in, amend the application if needed, and tie that in, granted, it would still require some more public input meetings, but if we could process those together, because we're talking about, for at least the aspect of pipeline safety and flume modeling, the same witnesses, and so having 2 hearings on those would be almost impossibly expensive on the short line. So if we could tie those together, that would be strongly preferable if they can think of a way to do that. Thank you.
Thank you.
Can I be heard on this briefly? So procedurally, the motion is on the table. That's first. You return an application when there's a reasonable belief the applicant could comply but has not yet done so. That's not applicable here. You deny when applicant can't comply. That's the evidence. So that motion respectfully needs to be decided first. What Mr. Kennedy just said was an additional motion. That's second in order. And I will argue that because the motion by staff and that we joined is on the table, and that I think we're all pretty clear, no, I shouldn't say that. It appears from the facts and the evidence that denial is the only possible path that legally and factually fits. I believe a motion has to be made as to that and decided, and then that frankly should dispense with any very late request that Mr. Kennedy just made, which I believe is inapplicable because of the timing and the fact that procedurally the commission needs to deal with the first motion first. Thank you for that.
You are correct. As a person who taught parliament procedure, I'm well aware of that. But I appreciate you pointing it out. We have a motion that we presented, a formal one, and it's on the table, and that is the one we're dealing with. And Commissioner Hayter.
Are we looking for a vote at this time?
No.
Looking for a motion? I gave my comments.
Right. I'm looking for a motion pertaining to accepting, rejecting, what is it? You had indicated that you were going to make a motion.
I'm ready to go then.
All right.
I would like to make a motion HP 22-001 to deny the application.
So you are accepting the motion to deny the application submitted by Ms. Edwards. Is that what you're saying?
That's correct.
Okay. So discussion on the motion, and having made the motion, you have the right to speak to it first.
I believe I made my comments pretty clear in my statement.
Okay. Commissioner Nelson?
Substitute motion to deny the motion to deny, to rescind our order imposing November 15th as an ultimate deadline for a decision in this matter, and indefinitely deferring the hearing pending a new scheduling order.
Remarks on the motion?
First of all, I want to say to staff, thank you for bringing the motion. As I said, these things were all swirling in my head. I wasn't sure how this was all going to shake out, and with your motion on Friday, it put the wheels in motion for us to bring this to a decision point early in this process. I appreciate that. I also fully appreciate the immense amount of work that has been put into this by everyone. Summit, by the landowners, by staff, by commissioners, by commission staff, the folks that are sitting in the back. Everybody's put a tremendous amount of work into this. And it doesn't seem to me to be fair to simply throw all of that out with a motion to deny. When in fact, Summit is saying with time, they can cure these deficiencies. I don't know if that's true or not, but I'm willing to give them the opportunity to go back and work with counties and with landowners to see if in fact they can cure these issues. And I don't know how long that's going to take. I suspect 90 days might not be enough, but I'm willing to give them the time, and hence my motion. Let me say one other thing. I do not believe that today or at the end of 3 weeks that they would be able to comply and get a permit based on the things we've talked about this morning. I just don't see that as being possible, and hence am willing to give them an opportunity to try to cure.
Further discussion on the motion. I will not be supporting that motion. I believe the first motion, main motion on the table, is appropriate. There are a number of discussions that have taken place today about the timeline, the amount of work that's been already expended in this process. And it's not just the applicant that's going to be going through this process, but everyone here. And it's not a matter of throwing everything away that's been done up to this juncture. It's a matter of that all of those things, all of that work, all of the routing and et cetera, for the most part has been done. There will be some work, obviously, that needs to be done in order to comply. And we need a clean process here. The schedule alone of trying to organize this particular meeting for 3 weeks is a huge challenge. And to simply examine just from the standpoint of what the county, or what the applicant needs to accomplish prior to being able to even get to a juncture where we can now say, okay, now the applicant is finally ready. The applicant had a responsibility to be ready when they first came here. Obviously, they were not. Their own application controverted itself. And so it's not fair for everyone to go through an entire process, hundreds of people that are involved, and then postpone it until we don't know when the applicant will finally say, okay, we're now ready, and then we have to go through this process all over again. They need to simply get their order of all of their things accomplished and done, and then say, okay, now we are ready to go through this process. Commissioner Hayter.
Concur with it needs to be a clean process, and I would also like to take a moment and just thank everybody for the thousands of hours that everybody has put into this process, and I'm prepared.
On the motion, Commissioner Nelson?
Aye.
Commissioner Hayter?
Aye.
Hanson votes no. Motion carries. Do you know what you're voting on?
Which motion we're voting on?
You're voting
Substitute? No. Let's go back then. Sorry, new guy.
You argued.
New guy.
You argued and you have.
Yeah, you looked at me and I'm like, which one are we voting on? My apologies. No on the substitute motion.
Well, my fault as someone who has taught parliamentary procedure. The parliamentarian is always supposed to state the motion prior to calling for the vote. So on the substitute motion by Commissioner Nelson to deny Hader motion and to, I won't repeat the entire, to supplant the motion by Commissioner Nelson, and I vote yes is to support Commissioner Nelson's motion to, and I vote no would be in opposition to that, and that would take us back to the main motion. So, Commissioner Nelson.
We're voting again?
On the same motion.
Same motion, aye.
Commissioner Hader.
No.
Hanson votes no, the motion fails. We're back to the main motion, discussion on the main motion. Commissioner Hader, it's your motion. Do you wish to say anything?
I've made my comments clear, no more additional comments.
Any further discussion on the motion? Commissioner Nelson.
I'm going to support the motion, even though this isn't my preferred motion. As I look at the two sections of statute that we've been working on this morning, we could go through 3 weeks and we would have a lot of this issue resolved. And Mr. Kennedy talked about getting the technical aspects of this on the record, getting that part of it out of the way, and we could certainly do that and have an understanding of where we're at with all of that, with the health and the safety and all of those kinds of things. But at the end of 3 weeks, I do not see that there's a way that we can get past section 1 of 22 or the last sentence of 28. And so I'm going to support the motion and we'll start clean.
Further discussion, a permit cannot be legally issued if the evidence shows that the applicant cannot comply with the statute, and that's the challenge that we're having here. I believe that the applicant will be able to come back with eventually a clean application. And when they do, that is when it is proper to examine it and have our debate and lengthy hearing. So with that, we will take a vote on the main motion. The main motion is to accept the motion to deny by Ms. Edwards. A vote yes is to accept it. A vote no, it's a motion by Commissioner Hader to accept the denial application from Ms. Edwards. A vote yes is to accept the motion. A vote no is in opposition to the motion. Commissioner Nelson.
Aye.
Commissioner Hader.
Aye.
Hanson votes aye. The motion carries. We have other motions before us, but we will not entertain those because those have nothing to do at this juncture, and they can be dealt with by the applicant in cleaning up their process. With seeing no business before the commission to proceed at this time, I will entertain a motion to adjourn.
Move to adjourn.
All those in favor of adjournment will signify by saying aye. Commissioner Nelson.
Aye.
Commissioner Hader.
Aye.
Hanson votes aye. This meeting, this hearing is adjourned. All right.